This program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts. Different jurisdictions have different laws and regulations, and because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. He is Marshall Chriswell. He is that attorney we were just speaking of. Good morning.
Good morning.
It's good to have you with us.
Nice to be here.
All right, let's talk a little bit about legalese. In particular, one term that we hear a lot, whether it's in Congress or in a court of law, and that is the word subpoena. What is a subpoena? And if I get one, what am I supposed to do with it?
Sure. A subpoena is essentially it is a court order, and it tells somebody, okay, you've got to show up at a particular time, a particular place to provide testimony and maybe also evidence, physical evidence, documents or something that relates to a proceeding. Mm-hmm. Now, subpoenas are issued all the time in both civil and criminal cases. Any party to a civil or criminal case has the right to subpoena witnesses to come into any hearing or a trial on the issue and provide relevant testimony.
Okay, ramifications. When I get a subpoena, if I choose to ignore it or if I pretend I didn't get it, if I don't show up, what happens?
So if you don't show up, if you don't comply with the subpoena, you are in contempt of court, assuming that the subpoena was validly issued. And that you don't have some other good cause for not complying, you're in contempt of court. So, what happens if you're in contempt? Might the court fine you, issue monetary sanctions against you? Maybe. Mm-hmm. And are they going to maybe send the sheriff, a sheriff's deputy out to find you and bring you to the proceeding? Possibly. Mm-hmm. So. You know that those are some of the ramifications that you're looking at. So it is a court order, just like any court order. You want to comply because the court has the power to enforce its orders.
All right, I get a subpoena in the mail. I'm not sure what to do. Do I need to call my attorney right away?
You absolutely have the right to an independent attorney if you are called as a witness in a civil or criminal proceeding, and there can be good reasons that you want to do that. If you, for one, you may have questions about, okay, what is there anything that I can avoid testifying to? Maybe you're a business owner and you're being called to present records and to provide testimony on things that you think are confidential, things that you wouldn't want to, whether they're trade secrets or other confidential information related to the operation of your business that you wouldn't want to disclose on the record in court, or you wouldn't want to provide voluminous documents related to that. Mm-hmm. Are there ways that maybe you can still comply with the subpoena, but also protect some of that information? So that's one example of a reason when you might want to have your own attorney involved. What if it's a criminal case, and what if you're kind of wrapped into this situation and you think, man, if I testify, am I going to be charged with something here? Did I do something wrong? There are, and an attorney, your own attorney can advise you, okay, there is some, you can pick and choose what we're going to answer here because you have protections under the Fifth Amendment of the Constitution against self-incrimination. So there are lots of good reasons that you might want to consult your own attorney if you're served with a subpoena.
Let's talk about timeliness. When you get a subpoena, is there generally enough time for you to go through that whole process of contacting an attorney, the attorney making the time, and you getting to sit down and make the meeting with them? What sort of time span are we talking about?
Yeah, that's a really good point because sometimes this happens really quickly. When as an attorney, when I obtain and serve a subpoena on someone, I send it out to be served either personally by a process server or constable, or I serve it via certified mail. I am supposed to provide that witness enough time to adequately prepare and be available for the proceeding. sometimes, just as a practical matter, sometimes things happen at the last minute, and witnesses will receive subpoenas for a proceeding that's going to happen, in a week or less, and that's probably not enough time if you did want to consult your own attorney and really be prepared. So there are and that kind of brings me to another point. There are good reasons that a witness can file to, and the word is quash a subpoena. And one of those is not having adequate time to prepare. So you can quash a subpoena and say, okay, can we reschedule this to another time? And that's a valid reason. Other reasons that you can quash a subpoena, for instance, if you're outside of the jurisdiction of the court. If I'm here in Pennsylvania State Court and I serve somebody, some individual in Ohio to attend a proceeding in Pennsylvania State Court, if I just send a process server out and have them served, they can quash that subpoena. They can say, I'm outside the jurisdiction of that court. There are other procedures that I would have to go through to serve that person. So there are good reasons that you can get out of it, but you have to have a good legal reason. And
generally, a judge is going to be very, very generous with his time because he understands or she understands attorneys' schedules and people's schedules in general. And I think probably the judges, their concern is getting everything right. And so if you rush something through, there's the potential for a challenge to what was obtained through that subpoena. And so the judge wants to be sure that everything is done correctly.
That's right. And, one of the biggest negatives that I hear from clients whenever we're going through a court proceeding is how long things take. That's something that everybody kind of has a gripe about. Man, the court system really takes a long time to get things resolved. And it's true. Sometimes it does. But like you said, for good reasons, you want to make sure that you have, when it comes down to having a hearing, going to trial, you want to make sure that you have the best evidence presented on both sides, and everybody had an adequate opportunity to present the witnesses and evidence that they need to. And sometimes you're right, it's just a scheduling thing. It can be difficult, but lots of reasons you go through this process very carefully. And judges are very, in my experience, are accommodating for the most part and sensitive to those concerns.
So you get a call from a client who says, I've got this subpoena. This thing's going to cost me money. All of a sudden, I have attorney's fees all of a sudden wrapped up in this criminal case. I really don't think I need to be involved in this at all. That's an issue to be resolved. Plus, you're going to have that sit-down meeting with your client and go over, well, what can they compel me to say? What do I not have to say? There are a lot of issues that have to be covered right away, aren't there?
There are, and again, it's almost always, if you receive a subpoena to testify or provide documents, it's going to be time sensitive. There's going to be a date on there that says this is when you got to be there, or this is when you have to provide this information by. So you don't want to, unfortunately, folks have the propensity to let things sit. You get something in the mail that you don't like.
I'll wait for the second notice.
Yeah. You don't want to do that with a subpoena.
Mm-hmm. Yeah. Mm-hmm. But that costliness issue,
right?
I'm not involved in this case. All of a sudden, I have a subpoena. I have to hire an attorney.
Well,
that has to be covered.
No, your own attorney's fees are generally not going to be covered.
What I mean is, I'm going to have to cover that expense.
The person who's the person obtaining the services of the attorney, that's going to have to be paid for. As a fact witness, if you're subpoenaed as a fact witness. In a civil or criminal proceeding, you are entitled to a few bucks by statute. The last I checked, and I can't remember it might be $10 a day plus your mileage.
Oh boy!
At the legal rate, so you
that might not pay for the parking.
So you're gonna get a few bucks, but right, I think they'll cover your parking as well.
Yeah.
So,
okay.
Yeah.
All right, but it is a cost that is incurred, and so
it is.
It needs to be considered as you're going through this whole process.
Right.
But the second part of what I said was, now you sit down with the attorney. The attorney has to advise you on how to protect yourself in a court of law from revealing information that you don't want to reveal.
Sure. Sure. And that's, and that you don't have to have an attorney. You can show up and provide testimony, and, you provide truthful testimony and if you got nothing to hide and you have nothing to worry about, you can do that. But it's, as we've said, it's always better to obtain independent legal advice, even if it's just a brief consultation with an attorney, just to get your bearings. Why do you think I was served with this thing? What are my obligations here? How do I answer questions? All of those kinds of things that a layperson walking through the doors of the courtroom just wouldn't know.
Yeah, it's an unfamiliar setting, and with a subpoena to appear in court, it's generally going to be something you don't want to do, or else you would have been there right from the start. Correct?
That's right. If you're somebody that's involved from the beginning and you know you're going to be a witness in a case, you still may get a subpoena, just so that I serve all my witnesses, just so I'm sure, even if it's my client's mother or best friend, and I know that they're going to show up to court, just so that if something happens and they don't, I can say, Your Honor, I did issue a subpoena here. Yeah. So it's kind of a bootstrap, but you're right. Most of the time you're getting a subpoena, it's something that you didn't really expect, or certainly don't want to be involved with.
Yeah, and we probably need to understand a little bit, and we're running out of time. But as the attorney who wants to get the subpoena to have someone come and testify in their court case, there's a lot of considerations for you too, isn't there?
There are. I want to think about, obviously, very carefully about the witnesses that I call and what their testimony is going to be. It's a lot different than if I've got, like I said, someone who's friendly to my client, who is a good witness for me, and I can get a chance to interview them and really understand what their testimony is going to be, as opposed to, let's issue this subpoena and bring somebody in, and sometimes it's a different situation. So there are lots and lots of considerations when deciding what evidence and what witnesses to put on in a case.
Yeah, absolutely. Okay, so somebody wants to obtain your services in that respect, what do they need to do?
You can always give me a call at 724-465-5826. Come see me in the Atrium Building, downtown Indiana, or go online to westernpalawyer.com.
He is Attorney Marshall Chriswell.
Thanks,
Thank
Todd.
you. It is the voice of Indiana County, WCCS, AM 1160 and 101.1 FM. Fox News up next.